Good afternoon, everyone. Welcome to the City of Madeira Beach Code Enforcement hearing. My name is Bart Valdez. I'm the appointed special magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 20 years. I've been appointed to this position in accordance and with the authority set forth in Chapter 162 Florida statutes. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. Every effort will be made to hear all persons having relevant evidence, argument, or comments to offer related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in by the city attorney in just a few minutes. In all cases, since the city has the burden of proof, the city will present its case first. The respondent or property owner then will be given the opportunity to refute the allegations. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing and you will be provided with a copy by mail. Therefore, please make sure that we have your current address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated and to provide you a reasonable time to correct the violation by whatever means is available to you. Please be advised that you may be subject to a fine and a lien may be recorded on your property if the violation is not corrected by the compliance deadline. If anyone wishes to present any information to me today, it is necessary that you swear or affirm that you will tell the truth. Therefore, at this time, the city attorney will swear in any witnesses.
Anyone that's going to speak, you stand up and raise your right hand and be sworn under oath. You swear the testimony you're about to give is going to be the truth, the whole truth, and nothing but the truth? Thank you.
Okay, it's my understanding, Mr. Trask, that there's only one case on the agenda today. Is that correct?
That's correct. It's the first case, which is 13715 Gulf Boulevard, and I want to give an explanation as to the other cases, just so that you're aware of those.
Okay.
The case that's on the agenda under B, as in boy, that's 321 Bogosiega Drive. We need to continue that because we don't have good service on that particular case. Under C, the property at 546 Johns Pass Avenue, the property owners are being quarantined now because of COVID guidelines, and so they will not be available for the hearing, and so we've continued it for that. And paragraph D, which is a property at 914 Bay Point Drive South. That property is in the process of coming into compliance, and we've been working with the property owner on getting that done, and we've agreed to continue that case to allow compliance to be obtained.
Do you need me to enter any kind of formal order on the continuance on any of these?
No, sir.
Okay. All right, then that leaves the first case on the agenda, which is case number 2020.1236, 13715 Gulf Boulevard. Is the city ready to proceed?
Yes, we are.
Please call your first witness or start however you like, Mr. Trask.
Thank you. I'm going to call Holden Pinker. Holden, if you could tell us your job responsibilities here at the City of Madeira Beach.
Holden Pinkard with the building department. I issue building code violations within the city.
How long have you been working for the city?
5 years.
And how long have you been in the current position that you're in?
4.
Okay. The property that we're talking about today, 13715 Gulf Boulevard, is this a proactive case or was it complaint driven?
This is a proactive case.
Okay. Who's the owner of the property?
It looks like a Barbara Volpe in a trust.
And how do you know that?
The Pinellas County property appraiser.
If you're looking at the packet that was provided to the special magistrate, I'd like you to turn to pages 3 and 4 of 131 and tell me whether or not, or actually 3, 4, and 5, and tell me whether or not you recognize those documents.
Yes.
Okay, can you tell me what they are?
3, 4, and 5?
Yes.
The Pinellas County Property Appraiser, record?
Is that the printout that you did to determine who the property owner was?
Yes.
Okay. If you could turn to page 6 then, it was also confirmed the same property owner by the tax collector?
Yes.
Okay, and you did the printout from the tax collector, and that is page number 6 in the agenda packet, correct?
Correct.
Okay. So, this being a proactive case, can you tell the special magistrate what you found, or what the city found was in violation of the city code, and when did you find that?
Deputy Snyder was doing his typical drive through the city and found work being done at the property. The driveway was torn up and looked to be like a new driveway was going in.
Okay. So did you go out to the property and determine yourself whether there was a violation of any particular city code, or
Yes.
did you rely upon the deputy?
I relied on the deputy.
Okay. And what was the actual violation that was found at that time?
Work without a permit, or the violation section 86-52 when required.
Okay. That's the provision of the city code that requires a building permit for this type of work?
Right.
Okay. So you do need a building permit to replace a driveway then?
Yes.
Okay. Did you issue a courtesy notice to the property owner that it was a violation to do the work without a permit?
Yes.
And when did you issue that courtesy notice to the property owner?
July 28th of 2020.
And is that what's reflected in pages 7 and 8 in the packet?
Yes.
Okay. How was that sent to the property owner?
Regular mail.
Okay. Did you hear from the property owner after that letter had gone out?
I don't recall, no.
Okay. Did you subsequently issue a notice of code violation on the same property for the same code violation?
Yes.
And when did you do that?
September 24th, 2020.
And in that, the September 24, 2020 letter, did you set forth the property address and parcel ID number and the exact code violation that was being cited?
Yes.
And that's in pages 9 and 10 of the packet?
Correct.
Okay. And how did you send that to the property owner?
Certified mail.
Okay. And is that reflected in pages 11 and 12, the green card and the signed green card?
Yes.
Okay. Now, the letter is dated September 24th, 2020. When did you mail it on that date?
Yes.
Okay. And does the green card reflect when it was received?
Yes.
What date was that?
September 26th.
Okay. After the letter being received on September 26th, did you hear from the property owner?
I don't believe so, no.
Okay. Did at some point the property owner come in and apply for a building permit?
Yes, December 29th of 2020.
So 3 months later?
Correct.
Okay. When they came in and applied for the building permit, did they list the value of the job and the square foot of the work being done?
Yes.
Okay, and can you explain what the value of the job listed was?
The value was put at $400 and roughly 360 square feet.
Okay. And once this application was received, was it reviewed by the building department?
Yes.
And was it found to be in order so that the building permit could be issued?
No, it was denied based on the valuation and the average, or the approximate square footage.
Okay, so he underestimated the value of the job and also underestimated the size of the job. Is that the bottom line?
Correct.
Okay. Did you or someone from the building department notify the property owner that it couldn't be issued because those were inaccurate?
Yes.
Okay. Was it determined at some point what the estimate of the cost would be for the value of the job?
Yes, it looks like page 19 has the average right around $5,800, and that is based on 375 square feet, and from the pictures that we have, it appears the entire driveway, including the rear yard, was paved, so not just that pink section or yellow section that was highlighted on the survey, and that's on page 20.
Okay, so it's greater than 360 feet by a long shot?
Correct.
Okay, so I'm going to back up just a little bit. So the building permit application, that is in the packet as pages 13 through 18, is that correct?
Yes.
Okay. And it's marked on page 13 that the building permit application was denied, correct?
Correct.
All right. So in looking at page 20 of 131, can you explain to the special magistrate what this document is?
This is a survey that was provided by the property owner. Now, I don't know who highlighted what, but it looks like the owner originally highlighted the yellow, and that would be the driveway that was going to be replaced.
Okay. And has the city done a calculation to determine how big that area is, the entire yellow area?
I believe I don't have the number in front of me.
But it was estimated greater than 360 square feet.
Correct.
Okay. Once the property owner was notified that the permit was denied, did the property owner come back in and provide adequate information and pay the building permit fee?
I believe we have received a revision since we notified the owner that it was denied. It's still yet to be obtained, and the specific courtesy notice or the notice of violation was to apply for and obtain a permit.
Okay. So the permit has not been issued as of today?
Correct.
All right. So did the city issue a notice of hearing for today and an affidavit of service for this property?
Yes.
Okay. And can you just go through and tell me what pages 21 and 22 reflect in the packet?
The affidavit of service.
And that's to tell us that the notice of hearing was issued by return receipt?
Correct.
It was also sent by by first-class mail?
Yes.
And was it posted on the property?
Yes.
Was it also posted here at City Hall?
Yes.
Okay. And pages 23 and 24, can you explain what that is?
The statement of violation or request for hearing.
Okay. And is this similar in nature to the code violation notice that was issued back in September?
Yes.
It specifically states the address of the property, the parcel ID number, and the fact that it was a violation of section 86-52 of the code?
Correct.
All right. And what is pages 25, 26, and 27?
The notice of hearing.
For today's hearing?
Correct.
Okay. Now I'd like you to turn to the pictures that we have in the packet. Specifically, let's start with page 28. And can you explain what this picture depicts? Who took this picture?
This is a Google Maps picture.
Okay. And what are we looking at here?
So this was before the driveway was replaced. It looks to be a concrete driveway when this picture was taken.
So the driveway that you're referring to, is that the one with the white car parked way in the back?
Yes.
Okay. So it's between the brown building and the goldish color building?
Right.
Okay. All right, I want you to turn to page 29 and tell us what this picture depicts.
This is when the work was being done. It looks like there's a backhoe and a gentleman there just tearing up the driveway.
Okay. And then the picture on page 30, what is that?
And that's the new paver driveway.
So it goes from the front all the way to the back and wraps around the back of the house?
Correct.
Okay. All right. So the property is still in violation as of today?
Correct.
How much time do you think it would take to come into compliance? If they were to come and provide, the property owner, provide a new building permit application, how much time would it take to go through the review process?
I think 30 days is a reasonable amount of time.
Okay. And what would they have to do what information would they need in addition to the application that they've already provided the city? Anything additional besides the value of the job and the square footage?
I believe there's an impervious surface ratio sheet in here that'll have to be revised. And the value of the job is going to have to be revised as well as the square footage to be a more reasonable number. And I think the building official uses the Florida Building Code as far as the valuation needs to include materials and labor.
Is the building permit price or fee based upon the dollar amount or the value of the job?
Yes.
Okay. So that's another reason why it's important to know the value of the job.
Correct.
Okay. All right. I have no other questions of Holden.
First of all, is there someone here on behalf of the property owner, the respondent?
Yes, I am the property owner.
All right, come on forward, sir, and give me your full name and address.
Sure, my name is Vince Volpe, spelled V as in Victor, O-L-P-E. My address is 13715 Gulf Boulevard, Madeira Beach, Florida, 33708.
Excellent. All right, Mr. Volpe, here's what we get to do first. You've heard Mr. Pinckney testify. You're going to have the right to ask him some questions, to do cross-examination, and then after that, the city will have an opportunity to call any other witness they want to call. Then you're going to have your opportunity to tell me directly anything you want to tell me.
Sure.
So this portion of the proceeding is just to ask Mr. Pinkard questions. Before you do, though, I want to ask him some questions. So I'm going to ask him a couple of questions, and then you can ask anything about what I asked or what Mr. Trask asked.
Sure.
So, Mr. Pinkard, so I'm fully up to speed on this, when they submit, property owner, respondent submits an application, they need to tell you, is it just the cost of labor, or is it cost of labor, materials, and supplies to the job as well?
Materials and labor.
Gotcha. And that's where on page 19 of the packet, that 5832, 5,832 is an estimate for both the cost and the materials. Is that correct?
Right, and that does, but that only, I think that only included the yellow section that was highlighted on the survey.
Gotcha. And then going to that's page 20 of 131, I'm just kind of looking at the numbers here. It looks like the distance is about 50 feet, the home is about 50 feet, and I see a dashed line about another 15 feet. So even on the original document here, it looked like it's probably 65 feet long by about 10 to 12 feet wide.
Right, and it does wrap around underneath that wood balcony as well.
Now, I see something on here that says sewer line repair. Just so I understand, is that something that the owner was doing, or is that something the city initiated in that regard?
I think in the beginning that was the issue. That was the main issue, and I believe the property owner had that replaced. Permits were pulled and acquired, and ultimately, what the city found initially was the driveway. That was what caught our attention. I don't think the city knew about any plumbing issues at the property.
Understood. Now, you said that the respondent has now submitted another permit application, or has not submitted a permit?
A revision to the one that's included in the packet.
They have submitted that revision.
Right.
So the 30 days is to allow the respondent or allow the city to issue the permit and the respondent to pay whatever fees would be required under that permit.
Correct.
All right. Okay, Mr. Volpe, you've now heard me ask questions as well as the city attorney. Do you have any questions for Ms. Pinkard? And again, I'm going to give you an opportunity to tell me anything you want to tell me, but do you have any questions for him, just like
I do.
what I asked?
As a matter of fact, I was issued the courtesy notice in the mail. It did come in the mail, and I did come in and speak directly to Mr. Pinkard in his office about it. So I came in, and then we talked about how it broke. I had a it was an...
Hold on, because I want all this, but this is just to ask questions of him. Do you have any questions?
Well, I'm trying to refresh his memory. So
okay.
Try to think back and remember when I came in. We talked about how it was an emergency. I had a sewer line bust under my driveway. I mentioned that the reason that I knew it had busted under the driveway was because for the past 2 years we have had a busted sewer line about 40 feet into Gulf Boulevard. Mm-hmm. The Pinellas County, I remember I mentioned it to you, Pinellas County has been still trying to get that resolved. But what has happened is that periodically it backs up. Well, throughout the 2 years, it's backed up maybe 3 or 4 times. This time, when it did bust, I had water, sewage coming up right through the driveway. So that's how I knew. I said, okay, well, wait a second, it's not busted there. I have to get down, dig down, and find it. Do you recall me coming in?
I'm sorry, I do remember.
Yeah. So that's when I got the courtesy notice. So I came in and I applied for it, and then the permit that I applied for, you said there was a permit that was for sewage. I tried to apply for both of those at the same time, the sewage and replacing that section of concrete that I had tore out. So that's what so on the original permit, there was nothing mentioned about a driveway.
Correct.
Got it, okay.
All right, Mr. Volpe, anything else that you want to ask Mr. Pinkert about?
No.
Okay. Mr. Pinkert, and I'm going to let Mr. Trask ask any questions, but real quick, Mr. Pinkert, on the revised or revision to the permit application, is the city satisfied now with both the cost that the respondent has put down as well as the square footage of the area?
To my knowledge, the value hasn't changed. I'm not quite sure what the revision was. I think it was roughly a week ago. I don't know if Mr. Volpe remembers what specifically he revised.
I came in and I asked about the revision of the cost.
Okay.
And the revision of the cost is nowhere near what the city says it is. That's why.
Okay, well, no problem. And Mr. Volpe, you'll have a chance to tell me about that. I was just
Sure.
trying to see what issues are in dispute in regard to that revision. Mr. Trask, I asked several questions, as did the respondent. Do you have anything further for Mr. Pinkert?
Yes, I do. So, Holden, if you could look at page 30 of 131. This is a photograph after the pavers had been installed.
Yes.
You have that in front of you?
Yes.
Okay. So, the city sewer connection is where?
The black arrow that's pointing to the cap.
Okay, so that's the cap about a foot in from the edge of the concrete, correct?
Correct.
Okay. All right, that's the only other question I have. I would like to, first of all, I'd like to tender into evidence the documents that are marked pages 3 through 30.
Go ahead and accept that into evidence as exhibit number 1. Mr. Volpe, is there anything else that you want to ask this witness about?
No.
All right. Don't go far, because I'm not sure if Mr. Trask has anyone else. So, Mr. Trask, any other witnesses or anything else you'd like me to consider on this one?
No other witnesses at this point.
All right, I'll give you an opportunity to do closing arguments in a few minutes. All right, Mr. Volpe, this is the time in the hearing where you can tell me anything you want to tell me. You can provide me any documents you want to provide.
Sure.
And you can call witnesses if you want to call witnesses
Gotcha.
to talk in addition to what you're going to tell me. So let's start with you, though, sir. Go ahead.
Excellent, yes. The main thing I wanted to get across is that I had an emergency sewer break that was approximately 25 to 30 feet, 25 feet into my property. By the time we got down to it, we figured out that it was a coupling and a 3-inch PVC sewer line that had blown apart. So what we did is that I went through and I demoed the concrete that was extremely bad concrete at the time. I demoed it all out, brought all my equipment in. I have my own equipment. I do this for a living. So I brought all my equipment in and tore out the damaged concrete that I needed to get down to the sewer pipe. Ended up being a $2.50 piece that I had to put back together. I ended up gluing the PVC coupling back together. That's basically all it really was. Then after that, I took and removed the concrete that was damaged anyway. Simply by bringing a piece of equipment onto the land, I was going to damage all that concrete anyway. Removed all the concrete from that point, which is approximately 30 feet, 30.4 feet. If you look on that highlighted area on that plot, you'll see it's 30.4 feet and it's 12 foot wide. So that was the piece that got completely pulled out and replaced with pervious pavers. So what I did was repaired it and then put that back in. After I received the notice, it was a what do they call them? They call them courtesy notice. I came in to resolve the issue. Apply for a permit after the fact, they call it. So I came in for the permit after the fact, filled out the permit. On the permit, I was trying to ask, what do I need the permit for the replacement or repair to the plumbing, or the repair of the flat work afterwards? Which one do I need it for? And we assumed that both of them were being I assumed, that both of them were being applied for. So I get a notice back saying, you applied for repairing a pipe, and now your driveway's repaired. And I'm like, well, no, I applied for both. But anyway, came back in, reapplied. After I reapplied, they sent me a notice that it needed to be revised. 3 things they asked for. I actually have an email, if you allow me to read from the email.
Sure, just tell me who sent you the email and
Okay.
the date of
The email was sent by Zain Hussein, Planning and Zoning. Okay. And the email reads, hold on, let me open it up. And I had it open, of course it closed on me. Let me just type Zain.
Hey, take your time, you're the only one on the agenda. You're good.
Zain should pop up. It's a very uncommon name, so there it is, popped up. Okay, so what was sent to me was, the first one was, I have reviewed the permit of number 6242 of 13715 Gulf Boulevard, blah, blah, blah. See revised comments, and it asks down here, provide the dimensions of the above pavers. Well, I provided the highlighted area, but he didn't see the actual measurements on there. So I provided that. It says length and width. And then it says impervious surface sheet. That's this IP, I don't know what they're called. They call it an impervious surface ratio, ISR sheet. I informed him that there was an ISR sheet already filled out in the records. Amber had showed it to me. It was put in the records. He could not find it. I said, no problem. I'll come in and fill out another one. And then it says provide grades of the pavers to the adjacent lots and the streets, public right-of-way. So that's what I did. I came in and I sent him this in response. And my response was 12 by 30.4 of permeable 2-inch pavers to be were installed. The ISR, again, I said the ISR was there, and it was in the folder, but if you need me to come back in, I will come back in and fill another one out. And then I said the current grade. I showed how I dropped the current grade. I measured the elevation of the property next to me and found that I had a 4-inch to 6-inch drop to my side drive, and then a 6-inch to 8-inch drop to Gulf Boulevard. So I provided that information to him. Zane responded back after that. That date of that was January 28th. Zane responded back to me on that one saying, thank you for the information. The plans need to be revised. Please come in and provide those documents. Okay? I thought that's what I did, was provide the documents when I did when I answered the answers. Did not realize he wanted me to come in and actually redo it. So came back in, redid those 2 sheets. Redid the one that had the actual highlighted area on it, and redid a new ISR sheet. And then after that, I came into the office, came into the building department and asked about it. And as you see, like I said, they did not ask at the first, the adjacent lot, blah, 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 but he did not ask anything about the price. So when I came in, I had a $400, that was paying for my work for the day, is basically all it cost. And I put $400 on there. He came out, he didn't. Amber went back and asked him, well, what do you want on this? And he says he wants $5,800 on there. And I said, it didn't cost me $5,800. I can't put $5,800 down on, this is according to what I'm understanding, this is a municipal document. I wasn't going to put a $5,800 price tag on something that I paid $400 for. So he says, well, that's the price, that's the average price of what it goes for. And I said, okay, well, that's not what I paid for it. So how I was at an impasse. I says, well, let me go, let's go before the magistrate and let me explain to him, that's what I paid to have this thing done. And this is where we are today.
All right, thank you for that very thorough explanation. Mr. Volpe, now Mr. Trask is going to have an opportunity to ask you some questions.
Sure.
And I may or may not have questions for you. Go ahead, Mr. Trask.
Mr. Volpe, are you a trustee of the property?
Yes, I am.
Okay. Who's Barbara?
That was my mother.
Okay. Is she alive?
Yes, she is.
Okay. Do you live on that property?
Yes, I do.
Okay. What do you do for a living?
I am a retired industrial electrical electrician. I semi-retired, and then I got pulled back into teaching by my wife. So I teach for Pinellas County School District. I teach electrical and construction technologies.
Did you own your own business as an electrical person, electrical?
No, not as an electrical contractor, I did not.
Okay. Was it your responsibility when you were in business? First of all, how long were you in business as an electrical contractor?
Since, let's see, 26 years.
Okay. And had there ever been a time when you did electrical work on a home that of this magnitude, for example, you're tearing up property, tearing up a driveway, that you never pulled a building permit?
No, I do pull building permits. That would be something that's done by what's called the supervising electrician. But
you realized when you were digging this up that you needed to get a building permit. You just didn't get one because it was an emergency.
Yes, exactly.
Okay. All right. Now let's talk about the work that you did on the property. You value your labor as $400.
Yes.
For 1 day's work.
Yes.
How much did you pay for the pavers?
The pavers were, they were actually left over. I've got 10,000 square feet of them. I paid roughly 50 cents a foot for them, I don't know, maybe 8, 9 years ago. I still have roughly 6,000 feet of it left.
How many square feet of pavers did you put down?
About 369 square feet.
Well, we know that's not true, sir, because of the fact that the property is 65 feet deep, and you have pavers from the front of the property to the back of the property.
I did not work on the pavers in the back of the property at all.
Okay, so you have a copy of this photograph that was taken of your property?
I do not.
Okay, let me go ahead and hand it to you.
Sure.
Is this page 28 that you're showing him?
30.
30, okay.
Mm-hmm. Okay, let me give you the other two photographs, too. There's one more, sir. So let's look at page 28, which is the photograph of the property before any work was done. No, that's page 30, the bottom right-hand corner.
This one?
Yes, sir.
Yes.
Okay. You can see that property, that's the property we're talking about, your property, correct?
Yes.
Okay, in the driveway itself, it looks like there was a white car parked in the very back?
Yes, there is.
Okay, so it's pavement all the way from front, all the way to the back?
It is, yes.
Okay. All right, and then, so in that picture, it's showing it was Google Earth in 2019. That's what it shows on the front.
Correct.
Okay, I want you to go to the next picture then.
Mm-hmm.
Page 29, where it's showing that you're doing work on the property, and it looks like you're tearing up all of the driveway from the front of the property all the way to the back.
Incorrect.
Okay. When was the property torn up from the distance of 30 feet back, from 30 to 60 feet back?
The property was never tore up from the distance of 30 feet back.
Okay, so
it is still concrete. It is known as stamped concrete. The same concrete that was there is actually stamped concrete that is still there. The concrete that you're looking at in that picture prior to that would have been raw concrete. This section where that machine is sitting right there forward has been all tore out completely.
Okay.
Where the machine is actually sitting is actually on concrete.
All right, so when you look at the picture number 30, and it shows pavers from the front of the property all the way to the back?
No, it does not. That is stamped concrete. If you look further back, the concrete starts right here. That is stamped concrete.
Sir, can you come up and, can you come just a little closer to Mr. Trask?
This shiny surface right here, that is stamped concrete right there. That was original concrete that's sitting there. This concrete that was right here, this was already completely done. I got this from the building official today. Backyard. That was all done.
Okay.
Prior to any of this being done. Okay?
So the portion that you're saying is stamped concrete, that's
Yes.
the highlighted portion, this little square in the very back. I'm talking about from the front of the property all the way to the back, this is all paver. Except for that little spot you're pointing at.
Except for the stamped concrete that runs all the way, the length of the property.
Okay.
Yes.
All right. So when did the paver work begin from 30 feet all the way back to 65 feet, except for the stamped area?
I have no idea.
Well, obviously, it was done sometime between the first and the second photograph.
No, this was all back there. This photograph that you're showing me right here, this photograph right here, which was, what number you call that?
Bottom right-hand corner,
Okay.
page 28.
Page 28. This right here is concrete, right from there back, and those were already concrete, that was already paper back there.
When did you pull a permit for the pavers in the backyard?
Never did it.
Okay, all right.
Never had paper, never, that was done prior to me being there.
So I want to back up again. So the materials you said, the 10,000 pavers that you had, you got them for how much a square foot?
Oh, I don't know what the square footage would have been on it because they were individual units. So the whole entire unit was 10,000 square feet.
Mm-hmm.
So I bought 10,000 square feet and it was less than, they were probably, let's do the math. If you do 4 bricks at 20 cents a brick, that's 80 cents then?
Is that what you think the value is?
That's what I paid for the bricks, yes.
Okay.
80 cents per square foot.
Okay, so if it's 80 cents a square foot and at a minimum you have 360 square feet, obviously the value of the job is more than $400. Would you agree to that?
I would if they weren't already free. You asked me what I paid for the original lot. The original lot I paid for was 10,000 square feet of brick. This is all leftover brick.
I got it.
Understand?
We're talking about the value of the work done. We're not talking about the cost of the work done, so.
Okay, I cannot answer any value to any work done.
Okay. So what is the reason that you have not paid for the building permit?
Because I asked, it was the value. When I came in, I asked them, what, can I pay for the permit? And he says, well, you have $400, it's too low, it needs to be $5,800. And I said, I'm not going to put $5,800 on there. That would be me lying on a government form. I am not going to lie on a government form to appease his,
I understand what you're saying.
you know what I'm saying? So I said, hey, it's $400. That's what I paid for them. I will be more than happy to pay for the permit based on what the cost was for me.
What was the difference in price in the permits between what you had originally asked for and what they told you to
I have no idea. Never even asked.
So we could be talking about $10.
Could be talking about 60 cents for all I know.
Okay, all right.
I have no idea. I was never told the original price of the permit, and I was never told the original price of the estimate that he gave. Amber in the office told me that it's something like 1-point-something% or something of the cost of the job. And I never even bothered to calculate that.
Okay.
I don't know what the cost is. Maybe Mr. Pinker could answer that question. I don't know what the cost of the permit is.
All right, I don't have any other questions for Mr. Volpe.
All right, Mr. Volpe, if I understood what you were saying, because I'm seeing the same thing Mr. Trask sees, but it's hard to say because we don't have any aerial photos, but I think
Yes.
what you're telling me is, if I'm looking at this picture right here where this white car is parked, you're telling me there were already pavers there.
There were pavers back there before I moved. Well, I moved down back to this house in probably 2010.
Okay, but I can also see, I mean, it looks like they match, so.
They do. They match exactly. They're called carabiner is the type of brick it is. It's a very common brick.
Okay. All right, so if you could come show me with Mr. Trask, I'm gonna walk over toward him. What I'm asking you is when you installed the new pavers, where did that come to?
It came to just past this door. If you take a good look, you can see grass growing right there. It's right up to that grass. This point from here to that point right there in the grass is 30.4 feet. It's actually shown on the plot survey. That corner is shown on the plot survey.
All right.
If you open to the plot of survey, I'm sure you have one. It looks like this. That corner is the corner that shows the grass right there.
So if I'm looking at this survey right here, that's page number 20, you're saying that
That's grass.
beyond the pink area is grass?
This right here is the grass edge right here.
Okay.
And that's the grass that you're seeing in that photo. If you get
Okay.
the photo back up, you can see, that's the grass you're seeing in that photo.
Okay.
Okay? And that's 30.4 feet.
All right. Mr. Trask, any further questions?
No, sir.
All right. Mr. Volpe, is there any other witnesses that you'd like to call, anything else?
None but me.
Okay. Mr. Volpe, have a seat. We're going to have public comment now. This is the portion of the hearing where if anyone wants to provide me with public comment, you can come forward, give your name, give me anything you want to tell me. So does anybody from the public want to come up? Is this restricted to this particular issue? Just this case that's before me. The 2020.1236, 13715 Gulf Boulevard. All right. Seeing no members of the public, we'll go ahead and close the public comment. Mr. Trask, before you do a closing, and I don't know if you need to call Mr. Pinkert again, I would like to get the answer to that. I just want to figure out what the parameters are we're talking about here. I mean, obviously, I don't believe the city is telling the respondent that the permit fee is $5,800. It would just be that would be what the permit fee would be calculated off of versus the other fee.
That's correct. So I'd call Mr. Pinkert, and maybe he can explain that.
Okay.
So, Mr. Pinkert, the question being raised is, what is the difference in cost for the building permit fee for what had been applied for by Mr. Volpe, and what would be obligated if it was at the $5,800 mark? I understand that there's some position or argument that the city has that there was more than $5,800 worth of work because that was only for the 360 square feet. What is the difference in the permit cost?
The fee across the board is 2% of the value, and then there's a $50 base fee. So, and if it's less than $1,000, I believe it's just the 50. So you're looking at maybe $50 or $60 based on the $400 value, and because it's after the fact, it would be 5 times that amount. So, and same would go for the 5,000. So, 2% of 500, roughly $100, and then, or 2% of 5,000, roughly $100 times 5. You're looking at right around $550, and that would be the permit fee because it's after the fact.
I'm just going to do
Yeah, go ahead, Mr. Trask.
my math.
While you're doing the math on that, Mr. Pinkert, I heard that we read an email about this, and I understand there's the sewer issue. Does the city have any discretion or authority to waive the 5 times penalty for after the fact, or is that not something the city can do?
Not to my knowledge, no. I've never seen it waived.
All right.
And there's been several after the fact permits since I've been here.
All right, Mr. Trask, I won't want to cut you off from doing your math, so.
So I did the math real quick. 2% of $5,800, if that was the number, is $116. So that would be a base fee of $50 plus $116, and my little scenario would be $166, roughly. But because of the fact that the permit was not obtained prior to the work being done, there would be 5 times that amount to get the building permit, correct?
Correct.
Okay, all right. So hopefully that answered my question. I don't know if it answered yours.
It does. Now, Mr. Trask, this is more of a legal question, so I'll ask you to see if your understanding is any different from Mr. Pinkert's. Is there any authority the city has to visit that after the fact 5 times?
No, there is.
And what is the legal mechanism if the owner says the work is not $5,800, it's $700, $800, $1,000, whatever it is? What's the legal mechanism by which the city and the owner come to a resolution on that issue?
So if there's a dispute as to a decision made by the building official, they could ask for the Board of Adjustment, in this case you as the special magistrate, to hear that and make that determination as to whether or not the opinion or the findings of the building official are accurate in relation to how this person is saying that the code could be read. But so it's basically an appeal to the special magistrate.
So right back before me again in a
different setting.
Now, in that regard, what is either the legal or even the past precedent of the city where you have a situation where the owner does their own work, their owner provides just an evidentiary hearing on why the city believes it's one number and why the owner believes it should be another number?
I'm not, so,
Right, what I'm saying is, assuming the landowner comes back before me and says, hey, we disagree on the permit, obviously in instances where the landowner uses a third party, an arm's length transaction, it's pretty easy to understand what in the real world this value costs. In this instance, we have an owner saying it's my own labor for a day and I have these pavers left over at X amount per square foot.
yeah, we would look at what the value would be. We'd have an expert come in and testify as to what the value of the work was, whether he did it or he did it himself or paid for it. That's how we would do it. It'd be the value of the work done.
Understood.
Yeah.
All right, and this, if I understood correctly, the respondent has submitted, Mr. Pinkert, you can ask this, the respondent has submitted the request. There's still this dispute over what the owner needs to pay in regard to the permitting fees, correct?
Right, and that, as the pavers sit, in my opinion, I think they're going to be over their impervious surface ratio, because there's got to be some grass or some amount of...
Now, is that an issue that's been noticed for me today? Am I doing anything on the impervious surface?
No,
Okay.
it's just whether or not there is a violation of the code in relation to not getting a building permit. So what we would do is in the city would, in the review process, when the application comes in, they would review that along with the survey, the application, and so forth, and make a determination whether or not they could build a driveway, they could paver as much as that they did. And then if not, they would advise them as to, well, you can do this much, this percentage, but you can't do the remainder. So that would be the option.
Okay.
In this particular case, if the ISR is over, we'd be asking the property owner to remove some of the impervious surface. In other words, take some of the pavers out. And then that would get him into compliance. That would get his number down.
But that, we're really putting the cart before, there's no evidence before me of any of this right now.
No, sir.
Okay. I know, Mr. Pickard, you asked for 30 days, but to do this secondary calculation and make sure it's right and everything like that, and I don't see a health safety issue here or anything like that, would 60 days be more appropriate to do the impervious surface ratio work that needs to be done?
I agree with that.
Okay. Mr. Trask, anything else?
No, I would just like to make a quick closing argument, though.
Yes, please do.
Okay. So, obviously, there's an issue as to the value. That's a disputed issue of fact that the city has determined that it to be $5,800 or more. Obviously, there's a dispute as to the square footage of the property that was paved over with pavers. I think that you can see from the photographs that, and the photographs that specifically reflects within the last year and a half, this property did not have pavers from front to back, and now it does. So that being aside from what the property owners testified to, the photograph is pretty clear that the pavers were added all the way to the back of the property. The value and the square footage of it is really, in my mind, not an issue for you to determine. You are to determine whether or not a permit has been issued, solely that. And there has been no testimony from the property owner that a permit has been issued, and in fact, the city has testified that there was no permit issued. So we believe that we have made our prima facie case that there is no permit, and therefore, there is a violation of the cited code section. We'd ask that you give the property owner 60 days to bring the property into compliance, and if not in compliance after that, to issue a fine of $100 per day. You have the right, obviously, to fine up to $250 a day. This is not a life safety issue, and therefore I think it would be appropriate to give a smaller daily fine than the maximum.
All right, and Mr. Trask, for purposes of doing this, do I reserve jurisdiction on anything else or simply issue the order and then let the landowner respondent initiate anything further in regard to the permit fee issue?
I think you should treat it like every other case that you have and not reserve jurisdiction and just issue the order.
All right.
and we can go from there.
All right, Mr. Volpe, I'm not unsympathetic to your circumstances, and certainly I understand this started with a sewer line. Mr. Trask and the city have carried their burden by preponderance of evidence, and the specific issue is this. It's whether you needed a permit for this work and whether you got a permit for this work. And based upon the evidence that I hear, there is no permit. The value of the work is more than $500. I see that even based upon your testimony, the cost of the supplies and your day's labor. And so what the city code provision says, if you're going to do work for more than $500, and this may even require a permit no matter what, but I find that the applicable ordinance does apply here. So I'm going to find you in violation of this ordinance, which is exactly what the city attorney just said. It's that you were required to get a permit for this work and you didn't get a permit. I'm going to give you 60 days to work something out with the city. As you may have heard me talking to Mr. Trask, there's another process by which you can come back if you have a dispute. I can't give you legal advice. I encourage you to go seek the advice of a lawyer. Mr. Trask can't give you legal advice. He represents the city. But you've heard us talking in this open hearing. There is an opportunity, if you still want to challenge the city's valuation, for another day. The impervious surface area ratio issue is not something that's before me today. I can't make any decisions on that. Again, I would encourage you to work with the city on that to try to resolve it, because what will correct your violation is getting the permit and paying all the fees within 60 days. That's the corrective action that's going to be in my order. Is that correct, Mr. Trask?
Yes, sir.
Okay, that's going to be the corrective action. So if you get a permit and you pay the fees within 60 days, then there will not be any fine on your property or any lien. If you don't, then, again, you need to talk to an attorney, because you may have $100 a day fine until you are in compliance. Okay? All right, and is there anything else? That will conclude case number 2020.1236.
I did not, I'm sorry. I understand that you and I talked about the $100 a day, but I don't think that you issued a ruling on that particular issue. You said 60 days for compliance. Are you finding that the $100 a day fine would be appropriate?
Yes, that's correct. So after 60 days, if the respondent doesn't have a permit and pay all the fees, that's $100 a day.
Okay, thank you.
All right, so that will conclude case number 2020.1236. I did hear a member of the public out there. Is there anything else, Mr. Trask, before we go to the member of the public here who had a question?
No, sir.
All right. Sir, come on up. There's nothing else on the agenda, but if there's something else that you want to address with the city that's appropriate today, we're certainly happy to hear it.
Thanks, I appreciate that. My name is Jerome Stockfish. I live at 319 Boca Ciega Drive. I am right next door to the direct west of the 321 property. I wasn't aware that that was taken from the agenda today, so that's why I'm here. And again, I have no standing in it except as a neighbor. I'm not sure what that means. We don't have good service on that?
It just, everybody, the owner is entitled to receive a letter, to receive certified mail so that they can show up. And so if there's something happened, for example, if they sent certified mail and it said could not find sender, I don't know what the service issue is, but the whole point is we're here to provide people procedural and substantive due process. The procedural due process is you've been given notice of the meeting. So obviously you got probably a letter or saw the sign that's posted in the front. Mm-hmm. The city is concerned, however, that the actual owner, the respondent, did not get notice today. And so they don't want to have to go through this hearing again 30 days, 60 days, 90 days because a letter didn't get delivered or something like that. They want to make sure that owners have the ability to come in here and defend.
Okay. Just let you guys know, though, that this situation is getting pretty dangerous over there. I think the hearing was for the submerged vessel, but the house itself is in really, really bad shape. Okay. There are open windows. There is...
I think that we should do this. This case is going to come before the special magistrate. You'll get an opportunity to express all that then. I don't think it's appropriate to hear it now.
Okay.
Yeah, I agree. What is the date of our next hearing? When will this be heard, so this gentleman is aware of that?
If you want to give us your name and address, I'll make sure that you have the answer to that question. The problem we have is the person has died, and no estate has been opened. And we have found no one that is an heir in the United States. We believe there may be an heir in Colombia or Argentina, and we're trying to trace that down, but we can't find someone that has an ownership interest in that property now. So that's what we're dealing with right now.
All right, well, sir, on my calendar, I see the next hearing as being on March 22nd. That's Monday, March 22nd.
Okay.
So plan on...
And I'm not even sure how much I can contribute to that, except to just, let you guys know.
Again, like Mr. Trask says, we have to confine everything to that. But I would encourage you, it sounds like you have seen with your own eyes evidence of a violation. That is exactly what public comment is about, is to allow people who have direct evidence of a violation to be able to testify. So you may want to talk with Mr. Pinkert or look on the notice. I'm sure this is posted somewhere in the city. Maybe here in the front, usually, if you look over there next to the desk, they usually have these agendas out there. So you can look a few days before the March 22nd hearing and see if that is posted.
Yeah, I did notice it was posted.
All right, thank you, sir.
Thank you.
All right, Mr. Trask, anything else for me today?
No, sir.
That will conclude today's hearing. Thank you very much. Mr. Volpe, you'll get an order in the mail when I get to it, probably just next couple days. Talk with these guys.